It's a great crowd so far, and I'm sure we'll have a few more people joining us shortly. So my name is Ailish Ryan. I'm a member of the Ard Comhairle for the Workers' Party, and we're delighted to have you here tonight to launch our latest, I suppose, pamphlet relating to trade unionism and workers' rights. And this evening, focusing on a world still to win, union recognition, a constitutional and human right, focusing on the importance of legislating and the possibility of legislating for mandatory trade union recognition in Ireland. And it's authored by Daryl D'Art, who is a member of the Workers' Party, has previously written a document for the Workers' Party, well, many documents for the Workers' Party over the years, but in my lifetime, one called Untying Workers' Hands, Workers' Party Proposals to Amend the 1990 Industrial Relations Act. And so we're going to be focusing on his most recent contribution, particularly in light of the committee, which is focusing on that issue at the moment and will be, I suppose, issuing its recommendations in due course. So Daryl's document, you'll get a good introduction to it from him and a response from Patricia King. I'll introduce them both properly in due course. And then I'm aware of just the scale of trade union experience and indeed trade union solidarity experience here tonight. And so in the Workers' Party, you know, we understand that there are many different opinions and perspectives on these issues, and we're delighted with that. So we're really thrilled that people are here and really encourage, I suppose, frank conversation as comrades for the rest of the evening following those two contributions. So the document is due to go up on our website tomorrow. So you're getting the very first introduction to it here this evening. If you'd like to be emailed a copy of the document when it's published tomorrow, I'm just putting a link there in the chat box, and you can fill in your details there. And we'll email you a link to the paper tomorrow and a copy of the paper tomorrow. And you're also welcome to add your email address if you'd like to be informed of similar events coming up over the next while. So I think nobody here would doubt the importance of the subject that we're addressing this evening. And myself, I know, I was just looking there, it's 3 years almost to the day since the Lloyd's strikes. I would have been out, like most people here, I suspect, in Stoneybatter with the women working in Lloyd's and Stoneybatter at the time. And, you know, there was absolutely no question about the commitment of the trade union. There was no question about the commitment of the workers involved. And so it is something else that's preventing success in industrial relations disputes such as that. And unless that's tackled in some way, I think, you know, retail workers in particular are workers who are going to be extremely, it's going to become increasingly difficult for them to make the gains that they deserve in the workplace. And so for me, I think the importance of the issue is really clear. So I had the pleasure of reading this document, and I'm really thrilled that Daryl took the time to put it together. Not just, I suppose, there's huge kind of legal expertise there that in relation to collective bargaining specifically and trade union recognition specifically, which I'm delighted with. But also I would really encourage people to look at the first couple of sections, which go into a great amount of detail about the history of I suppose, trade unionism and collective bargaining, particularly in Europe and the United States, and just some really interesting initiatives there that I think a lot of people, perhaps of my age and younger, might not have been familiar with. So it's a good combination, I think, of that kind of, I suppose, pop history of trade unionism, if Daryl doesn't mind me putting it that way, and really meaty kind of legal analysis as well. So I'm going to hand over to Daryl first of all to introduce the document. So Daryl is somebody who's been active in trade unionism in Ireland for a very long time, alongside his membership of the party. He started out as an aircraft engineer, maintenance engineer with Aer Lingus, and went from there to with the scholarship to Trinity, and moved into academia and focusing particularly on industrial relations. and he's taught in the University of Limerick, in Trinity, in the National College of Industrial Relations, the People's College, and most recently in DCU. And in his time in Aer Lingus, he was a shop floor activist and an assistant shop steward. Very recently, he had an article published in the Jurist about the same topic we're discussing this evening in the academic journal, the Jurist, and that's what formed the basis for the paper he'll be introducing now. And just to congratulate Daryl, 2 weeks ago, he was actually called to the bar as a barrister. So I, for one, am excited to see what trouble he manages to stir up with that. And I think it's brilliant, Daryl, really. I know it's been a long journey for you. So congratulations, and we're delighted now that you've, I presume, signed in blood that you'll be giving all your time back to us now that you're qualified. So congratulations, Daryl, and I'll hand over to you to introduce what's a really excellent paper.
Thanks, Eilish. Now, ladies and gentlemen, brothers and sisters, comrades, let me make a few opening remarks. Well, firstly, I want to thank Patricia for doing us the honor to come along and launch our booklet. Thank you very much. And also to the people who signed up for this Zoom event. Now, the bad news is that one of the few pleasures in my life now is talking. And so that means I can go on forever. But Eilish has sort of told me, or at least I've asked Eilish to sort of check me if I get out of hand and I go on for too long. I don't want everybody to go away and I'll be left talking to myself. Now, yeah, Eilish gave me a sort of a great introduction. The little failure in my life that I've ever made beyond assistant shop steward, I'm still hoping to be a full shop steward sometime, somewhere. Okay, now, the pamphlet. Yeah, the pamphlet is union recognition, a world still to win, union recognition, a constitutional and human right. Now, look, I'd be too long if I was going to go through, much as I'd like to go through each detail in the document. I'm not going to do it, but I'm going to really focus on two items. But before I go to those, just the document itself, it has a section on what do unions do, in fact, and why recognition matters. Then a historical section looking at union recognition over the years. Then a third section on union recognition and union legitimacy under partnership, which, anyway, we won't go into that. And then there's the three sections on the legal section, the Irish courts, the European Court of Human Rights, and the Constitution, and all that sort of thing, and the objection to it. And then a final section on, well, the problems with recognition and how we might be able to avoid that. So let me then start, really. What I'm going to do is two central questions. I'm going to do two central questions of our pamphlet. And the first question is, does Article 46(1)(3) of the 1937 Irish Constitution, which guarantees freedom of association or the right of citizens to form associations and unions, necessarily involve a concomitant and indivisible right to recognition of those unions? Now, we would argue it does. And how can we argue that? Because of a 2008 interpretation of freedom of association by the European Court of Human Rights. And secondly, the second question we're going to address is, would legislation for statutory recognition be repugnant to the Constitution and struck down by the Irish courts as unconstitutional? Now, we examined all the supposed obstacles to statutory recognition, and I have to say, I found them to be mere paper tigers, painted devils, lacking in substance, really. Consequently, apart from the opposition of powerful interest groups, and there will and always is, there are no obstacles, constitutional or otherwise, to statutory recognition. Now, some people may be unconvinced by this argument, though I'm going to try and sort of support it now in a moment. But we do have a trump card. Legislation on statutory recognition has been on the Irish statute book since 1924. and it remains good law. So let me go on to the above claims. The first one. Now, this interpretation of freedom of association. The right to freedom of association, the hallmark of a democratic state. But what exactly does it involve? What does it mean? Now, there are at least two interpretations or answers to that question. The literal interpretation. First is the literal interpretation. And the literal interpretation says, once workers can form and join trade unions, then the right to freedom of association is realized. That's one interpretation. A second interpretation is the functional interpretation. And this asks, what is freedom of association for? Why do workers associate in unions? Is it simply for the pleasure of association? I think not. Rather, workers join unions so as to exercise, through their collective, some influence on employer decision-making concerning their working lives, wages, conditions, etc. And this cannot happen until the right to form a trade union is recognized and the union is recognized. Let me quote, for instance, he's no radical now, the Canadian Chief Justice. He says, if freedom of association only protects the joining together of persons for a common purpose, but not the pursuit of the very activities for which the association was formed, then the freedom is indeed legalistic, ungenerous, indeed vapid. Another quote from a different case in the Canadian Supreme Court. The ability to engage in collective bargaining is a necessary precondition for the meaningful exercise of freedom of association. And according to the International Labour Organization, collective bargaining cannot begin until a union is recognized for that purpose. So, how have the Irish courts interpreted the constitutional right to freedom of association? Now, from the 1960s, cases in the Irish courts that have considered what freedom of association involves and means all came to the same conclusion, that the workers' right of association does not involve a corresponding obligation on the employer to recognize or negotiate with the workers' association or unions. It's all laid out in the pamphlet in that section on the Irish judiciary. The Ryanair judgment of 2007, the Supreme Court seemed to go even further. The Supreme Court Judge Hugh Gagan remarked, it is not in dispute that as a matter of law, Ryanair is perfectly entitled not to deal with trade unions. Now that statement followed the established precedent, as we've seen, but the judge went on to add, nor can a law be passed compelling it to do so. So, legislation facilitating recognition, the practical embodiment really of freedom of association, was apparently an impossibility. The Irish judiciary's interpretation of freedom of association sharply delineates and denies any connection between the right to associate in unions and a right to recognition. So that's really where it stands in Ireland. But what about the interpretation of freedom of association in the European Court of Human Rights? Now, like the Irish courts, the European Court of Human Rights adopted the same literal interpretation of freedom of association, that the right was realized once workers were free to form and join trade unions. Now, in 2008, the European Court of Human Rights made a radical departure from its existing case law in its interpretation of freedom of association. In this case of Demir and Bakira versus Turkey, the court rejected the literal interpretation of freedom of association, that the right was realized once workers were free to join unions. The court described this interpretation as theoretical and illusory. The court concluded that the functional interpretation of freedom of association must be applied to make the right practical and effective. At present, and it's very likely to continue because the court has reaffirmed its judgment, the European Court of Human Rights holds that the right of freedom of association encompasses not only the right to form and join trade unions, but the concomitant and indivisible right to union recognition and collective bargaining. A decision unanimously confirmed by the court in the first judgment on the first case, and in the second case also from Turkey, that was reaffirmed again unanimously. So what does this mean for Ireland? Now, we could take, I think it was Joseph Chamberlain, his line of 1938 on Czechoslovakia. He said, "It's a faraway country of which we know little." Can we take that line in Ireland? Not really, because Ireland is a contracting state to the European Convention on Human Rights. And according to the European Convention, a contracting state is obliged to take account of the elements regarded as essential by the European Court of Human Rights case law. Furthermore, it's a requirement of Section 4 of our European Convention on Human Rights Act 2003 that a court, an Irish court that is, shall, when interpreting and applying convention provisions, take due account of the principles laid down by those declarations, decisions, advisory opinions, and judgments. The European Court of Human Rights has unanimously rejected the literal interpretation of freedom of association, long applied by the Irish courts. From the ECTHR's perspective, the old dispensation that separated the right to form and join unions from the right to recognition and collective bargaining has no longer any legal validity. In other words, it's really null and void from the Europe. It's the wrong way to interpret freedom of association, according to the European Court of Human Rights. Now, it would seem then that the Irish courts, in dealing with future cases of contested recognition, must apply a functional interpretation of the constitutional right to freedom of association. This means that freedom of association encompasses not only the right to form unions, but an indivisible right to recognition of those unions for collective bargaining. Now, there is a snag or a qualification, and it's this. Should conflict or uncertainty arise in Ireland, say, should conflict or uncertainty arise in Ireland when applying the judgments of the European Court of Human Rights or the principles, the Irish Constitution will have primacy. So the old interpretation of freedom of association by the Irish courts, it now seems to be defunct. But are they obliged to take on the interpretation of the European Court of Human Rights? They are, if it doesn't conflict with the Irish Constitution. Now, the question arises, and that's our second part, what, if any, are the constitutional obstacles to taking this sort of functional view of freedom of association? Now, these have been kicking around for a long time, all these difficulties, supposedly. And what I did was, I looked at all the obstacles that I know of anyway, and that were raised by this. There was a constitutional review group set up in 1994, reported in 1996. It was supposed to look at the Constitution and what changes might be made, if any. And out of that, a small section of the report, it's a huge report of 700 pages, there's a small section on Article 40 on freedom of association. It looked at freedom of association and it came up with a variety of objections. And then there are other commentators who also have similar objections. And what I did in our pamphlet was go through each one of these objections in detail and examine them all. Now, I'm going to deal with them here, but you'll be delighted to hear in a very cursory fashion. We can't be here all evening. Now, the first, and it was really a bizarre Gilbert and O'Sullivan type paradox raised by the, oh, by the way, before I went to that, the review group did admit, they said, look, they said, if you look at the constitutional right to freedom of association, it isn't realized if the workers' union is not recognized. They recognize that, but then they went on to say, and they said there should be legislation really, but the problem was they had all these objections, and I'm going to go through some of them very quickly. The so-called horizontal effect. This is a real legalistic one, the horizontal effect. Now, you had the ridiculous sort of Gilbert and Sullivan type paradox that the right to form unions, the Constitutional Review Group came to the conclusion, the right to form unions could become a barrier to union recognition. It's quite incredible. While the state respects the individual right to associate, it should not, according to the review group, have a horizontal effect. What this means is that it should not affect the rights of other private persons, such as employers. Now, to accept that argument, it negates freedom of association. And indeed, and rightly so, I think, the review group's treatment of this supposed horizontal effect has been described as extremely superficial. A second objection, and these objections have been repeated by people without any examination at all. Second objection is the employer's right to dissociate. This is really, it's quite a meaningless objection, really. Across the Western world, no extant legislation on recognition requires the employer to join the union. Logically, it would be difficult to dissociate from an organization of which you are not a member, and that's the case with the employer. And anyway, in employing workers, the employer has chosen to associate with them already, or the workers group organized by the firm. So that right to dissociate is really quite nonsensical, in my opinion, though it's always bandied about. Then there's the property rights and the Constitution. And this is usually put forward as the big bogey, or the big bogeyman, or bogey person, should we say, the bogey person against union recognition. Now, think about it. How could union recognition, how would it actually interfere with a property right? It's really hard to see how it could. I think the confusion arises from running together two distinct concepts, a right to property and a right to manage. Now, sure, property rights furnish the owner with rights over property regarding its use or disposal. These rights do not extend to a right over people. The claim that an absolute right to manage naturally flows from enterprise ownership has long been contested. Well, of course, we know that. Indeed, the potential for exploitative abuse arising from an unchecked right to manage has necessitated continual and continuing state legislative intervention, political and trade union action. Statutory recognition is not so much an interference with a property right, but more a collective, humanistic, democratic qualification of management or employer power. Now, I go on at length, indeed, in the pamphlet to examine the articles in the Constitution dealing with property rights. And I can't really go into them now in detail. It's best to read them yourself at your leisure. But I can assure you that the property rights, the so-called property rights and the Constitution is not a barrier to union recognition, because property rights in the Constitution are always qualified by the exigencies of the common good. And if you can demonstrate, and I think I have, that unions actually make a contribution to the common good, not only the common good, but the democratic nature of the state, then they could easily escape any qualifications or any sort of constitutional infirmity. They'd really survive a constitutional challenge. I've no doubt about it, really. I'm sort of fairly confident about it. Now, the fourth one, voluntarism and, oh dear, voluntarism and statutory recognition. Now, this is a favorite objection. It's almost a fetish. It's almost a fetish. It's deployed continually by employers and by the so-called high-level group on union recognition of 1999. And IBEX, indeed, IBEX submission to the latest high-level group, again, voluntarism is the big bugbear to union recognition. Now, voluntarism is supposedly destroyed or undermined by the introduction of statutory recognition. On the contrary, we argue, and indeed, I think we, well, to my satisfaction, we establish that statutory recognition actually complements and fits easily within the voluntary tradition. It's not a problem. Now, the fifth one, statutory recognition and inward investment, constantly repeated assertions that statutory recognition will damage or discourage multinational investment here. There is not, to my knowledge, a shred of evidence to support these claims beyond sort of assertions. So, the principal reasons multinationals locate here our facilitative government policy, a generous taxation regime, and the easy availability of educated, skilled workers. In fact, union density levels are higher in foreign multinationals, including those of US origin, than in domestic private sector firms. Statutory recognition may be of more concern to domestic private sector firms than foreign multinationals. The US multinationals, they come from a country in which already has statutory recognition. I've dealt with all that in the pamphlet in detail, in much more detail. Now, the claim that a law, and this is the final bit, I think the claim that a law cannot be passed obliging Ryanair, or by implication any employer, to recognize and negotiate with a trade union may be mistaken. Now, the strongest, and yeah, I'll have to go back to that just for a moment. I'm getting confused here with my own stuff. Yeah, the impossibility of statutory recognition. Now, I've already the quote from Ryanair about that. Ryanair is not obliged to recognize a union, and a law can never be passed obliging it to do so. Now, the judge didn't elaborate on why statutory recognition was impossible. And if that's so, Ireland would be unique among Western nations. Automatic right to recognition in Scandinavia, statutory recognition in the UK, Canada and the US, statutory recognition. Both of these countries have constitutions, yet recognition is on the statute book. In fact, in the US, there was a constitutional challenge to statutory recognition and it failed. Existing legislation and the claim then that a law cannot be passed obliging Ryanair or by any implication any employer to recognize and negotiate with a trade union may be mistaken. Existing legislation that's Irish legislation, already imposes a series of miscellaneous duties of consultation and recognition on certain employers. The Universities Act of 1997, the Education Act 1998, the Institute of Technology Act 2006, they're all examples. However, the strongest and most unequivocal example are the Railways Acts of 1924 and 1933. These acts require that all terms and conditions of employment be negotiated between the employer and the trade union representing the employees. It is, in short, a form of statutory recognition. Now, these acts, sure, they predate the 1937 Constitution, but they've gone unchallenged and so remain good law. While they were amended by Section 46 of the Transport Act 1950, the provision remains that rates of pay, etc., of CIE employees be regulated in accordance with agreements entered into by CIE and the appropriate trade union. Now, that being the case, it renders much of the argument deployed by myself as sort of superfluous. The supposed solidity of the Constitution and other obstacles to statutory recognition, the employer's property rights, the right of the employer to associate, the horizontal effect, the incompatibility with voluntarism are all without substance. Now, my little final section, the good news, and it is good news, I think. Historically, unions or workers' collectives have not fared well in their encounters with the law, no doubt about that. Yet for once, it seems the law may serve Irish workers well. With regard to statutory recognition, Irish workers are advantaged by the constitutional guarantee of freedom of association. Given that a form of statutory recognition has been on the Irish statute book since 1924, and there are no constitutional obstacles to legislation on recognition, then there is an obligation on the Irish judiciary to interpret the Irish constitutional guarantee of freedom of association in line with the European Court of Human Rights judgment or jurisprudence. This means, in effect, that our constitutional guarantee of freedom of association gives Irish workers not only the right to form unions, but a concomitant and indivisible right to recognition. With regard to legislation, a constitutional right to recognition confers a great advantage on Irish workers. A legislative enactment giving practical effect to this right can avoid all the procedural complexity and the legal wrangling associated with statutory recognition in the US and the UK. In upholding the constitutional right to freedom of association, Irish legislation could only confer an automatic and unequivocal right to recognition. And there's already in existence a Trade Union Representation Miscellaneous Provisions Bill 2017. Though now lapsed, it remains a model of simplicity and elegance. What does it provide for? And it's a short bill. It's a page long, which is a marvel in legal terms. It's so concise. It's absolutely spot on. What does the bill say? It provides that an authorized trade union representing members for collective bargaining shall be recognized by the employer. Now, had that been enacted, it would have established an automatic legal right to recognition, which, when sought by the workers' union or unions. So had it been enacted, it would have established an automatic legal right to recognition. In doing so, the constitutional right to freedom of association would have become practical and effective and in alignment with European Court of Human Rights jurisprudence. And we are a signatory to the European Convention on Human Rights. In conclusion, now, I don't want to be overly dramatic, but it seems to me that union recognition is a life and death question for the Irish trade union movement, especially in the private sector. So, comrades, let us rally, and the whole of the Irish trade union movement unite behind the legitimate demand for a statutory recognition as the practical embodiment of the constitutional right of freedom of association. It's an old legal maxim that a right without a remedy is no right at all. Okay, comrades.
Thanks very much, Daryl. That was really excellent, and also
Okay.
not at all over time. So fair play
Good.
managing to get it all in there. Okay, so I'm just going to hand straight over to Patricia King, who is somebody that I'm sure everybody here is familiar with. Patricia is the General Secretary of the Irish Congress of Trade Unions since 2015. And prior to that, she was an official with SIPTU for 25 years, including holding the position of Vice President during that time. And she's worked across public and private sectors and will have a huge amount of practical experience to bring to the issue as well. So Patricia, I'll hand over to you.
Thank you very much, Ailish, and thank you very much for the invitation to contribute here this evening on this really important topic. And Daryl, I read your work, as I said to you earlier, and I think it's a very valuable contribution to the debate on the topic. I found the historical, as Ailish mentioned in her original introduction, I found the historical perspective on this to be particularly interesting. It's not something that actually you would find too often, and I thought it was really interesting. I think that the word pamphlet maybe understates the quality of the document, but I think that, you know, your work always deserves, I think, due consideration and analysis. But particularly so, I noticed with both surprise and satisfaction that in the recent Supreme Court judgment, McMenamin J, in his judgment, referenced you, Daryl, as part of his arguments that he set out in that judgment. So I think that in itself is something to be very proud of in terms of the value and the weight of the arguments that you make. So I suppose we're all familiar with the current nature of the Irish industrial relations framework. And as Daryl says, we operate in the voluntary system, whereby collectively bargained agreements, they do not have the force of law unless the parties agree that to be the case, which now is rare because the registered agreement is not applicable other than when the parties agree to have it. So there are a number of short scenarios, I think, for consideration that arise in the current framework that we have. So where we have collective issues and a trade dispute to be dealt with, and where recognition is conceded, you will find that workers are organized, they pursue their claim or their dispute directly, they may seek the assistance of a third party and of the third party system, and they may also decide to have industrial or strike action if necessary. And really, if the dispute is well managed, in a lot of these cases, as we have seen, the outcome will depend really on the strength of the industrial leverage of the workers concerned, and that really will determine the outcome. But I agree with, and I'll refer to this further on, but I agree with comments that Daryl has made in relation to the voluntary system being in some way threatened by trade union recognition. I don't think that is to be the case. And I think also that we have to be extremely careful in any discussions, deliberations, or otherwise on any of this topic, that we do not dilute in any way the ability to or the impact of taking industrial action. I think that that is a very valuable piece of our industrial relations. And as a person who spent a long time engaged in that, I don't think I'll ever change my view on that. So scenario one is a group of workers who are organized, who have recognition, who have collective bargaining, and who are in a trade dispute. They go through that system. And quite candidly, if you contemplated having a very strong density in industrial relations, trade union density, trade union representation, that system and the voluntary, that actually works quite well, because you can pursue your issues through the strike process if necessary, and by that you're forcing the employer by your industrial leverage to make a quality agreement with you. Then scenario two occurs in terms of industrial relations framework that we have, which is where within that system as well, you may have groups of workers, and Eilish referred to, for instance, the Lloyd's dispute, which is what happened here. You have a scenario where trade union recognition is not conceded. The workers organize themselves quite well. They want to pursue their trade union dispute. The employer is hostile, and they, outside of a reference under Section 20, which is a nonsense reference to the Labour Court because it's only binding on the party who refers it, workers can expect that they will have little or no assistance actually from the third party system. And there may be some argument to be made that Section 3 of the Industrial Relations 2015 Act might help them if they're talking about comparators and so on. But the comparator bar is so widespread that it's making this sort of fairly useless. So that scenario means that those workers who have not got a concession of collective bargaining or trade union recognition, but who have organized themselves, will go through the system and will try then to, through industrial action, which is what happened in the Lloyd's dispute, they will try then to force the issue with the employer. And if the pockets of the employer are deep enough, if the instinct of the employer is strong enough, they will kill off the dispute. In that case, they produced money for redundancies and put people in unenviable positions, quite candidly, at the end of the day. And those of us who worked in the trade union movement all our lives, and I see a lot of colleagues here that I know, they would have the experience of being involved in those disputes. And I can tell you, even on a personal level, there is nothing more heartbreaking than being involved in that, because it is just appalling where it takes you and where it takes the workers. And it does damage to the movement as well, in terms of you have gone out, you have organized interested workers, and actually they can become quite demotivated and quite disillusioned in the scenario. And the third scenario then that we have is where in the industrial framework, and it's not something we pay a lot of attention to, but I just thought it would be worthwhile bringing it to your attention. The third scenario is where you have workers in employments that are not recognized, have no recognized trade union representation, have no collective agreements. The employer holds all the power, determines the pay and conditions of those workers unfettered. And within this landscape, you have a very inequitable situation, because you have, unless those workers have sufficient industrial leverage, they can't exercise any influence at all on their terms and conditions of employment. And, that in itself demonstrates the need for trade union representation and rights within that trade union representation. And we know, we all have to agree, and I wouldn't in any shape or form demur from the points that Daryl has made, Ireland has very weak representation rights for trade unions, and certainly contends as a state that the obstacles to improving them are complex. So if we look across the effects of this on our labour market, I think it's worth noting that, you know, the facts are we have a collective bargaining coverage rate of about 33.5%. The average in Europe is about 60%. But our collective coverage is highly imbalanced across the different sectors of the economy, with the starkest divide probably being between the public and private sector. So the public sector accounts for 15% of the workforce. It's a well-organized sector. It could be a little bit better organized, but it's a well-organized sector. It has 15% collective coverage, as well as forming 15% of the workforce. And on that basis, that leaves us in a situation where, even doing the maths, you can see that about 18% of the private sector is covered by collective agreement, and therefore is, you know, entitled to have representation on its terms and conditions of employment. Now, that includes the SEOs that are mainly in construction, and it includes, albeit there's only 2 of them, the JLCs as well. So that really means that a huge, in effect, up to 80% of private sector workers have little or no influence on their terms and conditions. And the overall trade union density is at about 25%, which is actually up 2 percentage points since 2018, but still, which is not a bad thing. But still, what that says to you is we have a very strong cohort of workers who have no say or influence. And that does come down to our successive governments in terms of attitude to collective bargaining, attitude to trade union rights, and so on. So aside from the national minimum wage, which is legally enforceable, we have you know, a quick overview of the current suite of legislation, and the mechanisms available to us tell us that we have JLC system, Joint Labour Committee. Everybody is familiar with that. You don't need me to go into it. There are 8 sectors nominated, but only 2 operate. And the big flaw in that legislation is the employers have a veto. So when you go in to get your Joint Labour Committee together, and you make the application and the parties are asked to come in, the minute the employer says, I don't want this, the book is closed, night and God bless, you're not having it, end of. So the employer determines. That's a huge flaw in that system. It's inoperable. So unless they agree it, it's not happening. So there's a power imbalance. Then you go to the SEO. Well, the SEO has survived the recent Supreme Court, I see Paddy Kavanagh is on the call, the NECI challenge that came. And so from that point, it to some degree, it is. Now, I personally, although not everybody in the movement agrees with me on this, but I personally think that the element of the SEO that is very valuable to the trade union movement is that there has to be a level of representation, substantive level of representation, that, in other words, you have to draw in the trade union movement to make quality representation. And not only that, that act provides that the employer can go and disrupt the SEO if you don't keep the representation. So the link between organising labour and the actual instrument and mechanism for people's pay, that link is there. Personally, I think that's very bad. I'm not sure that the trade union movement has utilised it as much as they should or could, but there you go. The registered agreement now has been just rendered down to, after the McGowan case, it has been rendered to an agreement between the parties. They can agree to register it and it becomes somewhat legally binding. The 2015 Act doesn't confer collective bargaining rights. We know that. But it does facilitate a process for improvements in paying conditions at enterprise level. But there is a high bar, as I mentioned before, in relation to comparabilities, and the use of the Act is very low for that reason, because you're asking, the Labour Court has the power to seek comparabilities on the basis of unorganised workers and basically agreements that have derived from unorganized labor. And that's no fair comparison. So from that point of view, it is not that useful. It did do a number of things on foot of the Ryanair dispute. It did improve the definition of collective bargaining. It is now very close to the ILO definition. It did actually put a much more succinct definition on the accepted body, which again was a terrible demon in that Ryanair case. And it also, I think, reversed the onus of proof piece and converted it to the employer so that they had to, in substantive evidence, make their case rather than the other way around, which was to deal with the evidence giving in the Ryanair case. But some of those legislative amendments developed as a direct consequence of that Ryanair. Much has been made, and Daryl has referred to it on a number of occasions in his contribution. Much has been made of the Oberta Dicta comments of Gagan J. When he made those comments and so on, he signaled that companies had a constitutional right to operate a non-union company, that no law could be passed, and so on and so forth, not to repeat all of that. But these were arbiter comments, and in my judgment, they've received far, far too much focus and attention, because as arbiter comments, they should be left as that, as just the comments of the judge, but they didn't form part of the judgment. However, I do think, and this is not something that I have necessarily referred to before too often, but certainly it is clear to me now that we should be very cognizant of a litigation strategy, which has been pursued now for a number of decades. And by that, I mean, if we look at, and setting aside the Ryanair case, which was not unexpected challenge from a company in relation to the Constitution and the legislation 2004 Act. But in 2012, we had the JLC challenge from John Grace, followed in 2013 by the McGowan case on the registered agreements, followed in 2017 by the Necky case and the SEO challenge, which has taken itself all the way. And now in 2021, we have the JLC challenge in the security services. Okay. So I think there are some interesting features here that we should or could really focus on. Firstly, these challenges have been consistently led by very eminent lawyers. There's an interesting piece on that, is not only eminent lawyers, but the very, very expensive lawyers. The second thing is that they have been driven right through the judicial system, right up to Supreme Court level. There's been no holding back from that wherever required. And that's normally a very costly business. Could land you between €500,000 and €1 million to get to the other side of this. I've sought that out and I've asked people and they've told me that this is a possibility. But yet, I did, in the most recent one, I did a little bit of analysis myself of the companies involved, for instance, in the current JLC challenge. There are 3 companies involved. One has a value of about 450,000 overall and has something like 58 employees. The other 2, although they're named as 2 separate companies, one is the parent company of the other. Between the 3 companies, there are 218 employees. There are 13,700 workers in the sector who are now being denied their pay increase. But the company, the second company involved, there's a notification on their accounts that they may not even remain as a going concern because of a debt that they're owed. Their value at the moment is about 3 million. Now, none of that adds up to being able to contemplate these challenges, pay for these challenges, and get the best lawyer representation. And certainly in this one, they have a very strong lawyer representation. So it begs the question, who's paying for this? Who's doing this strategy? Because I don't believe, I think there is a strategy, a litigation strategy here, and I'm not sure we're seeing the full picture here. I think that's important because, not just from the actual, niceties of those details, the reason I'm raising it is, this is a demonstration of the lengths and the depths that people in the business community will go to ensure that low pay is maintained as a strong feature of our labour market. That's the reason, apart from the micro details there. So I think another feature of that Ryanair case was that the Supreme Court, when they were making the judgment, Gagan, he made no reference at all to European law. And, you know, in the context of Ireland as a member state and their obligations, he just totally disregarded that. However, it's interesting to note that in the recent Supreme Court judgment relation to the Necky case, at paragraph 139, reference is made to the Demer Turkey case by McMenamin J, and he observes that collective bargaining is now seen as a recognized feature of the social market within the European Union. So that's just interesting that we have shifted from 2007 to a Supreme Court judge declaring what Daryl referred to in terms of, you know, law can be passed and so on, to 2021 where a Supreme Court judge will make that statement. So in the EU law, Ireland is an outlier and is starting from a very low base in terms of collective bargaining rights. But the obligation on Ireland as a member state is reinforced really by our membership and by the EU law, and indeed by the international laws and the ILO. But if we look briefly at some of these provisions as have been referenced, Article 11 of the European Convention on Human Rights protects the right to freedom of association. That's a living instrument, and it must be interpreted in the light of present-day conditions. The European Court of Human Rights itself has indicated its willingness to further widen the scope of rights of workers and unions under Article 11 in line with developments in international law and European practice. However, one of the features that I think we need to draw out is, and to have an honest debate, is there is a killer line usually in all of these provisions. And the killer line is that whatever provision or whatever coverage it supports or provides for, it then says in line with national law and practices. And of course, that's the killer line in Ireland, because our national laws and practices are so deficient in this area, and the bar is so low that the application of the European instruments then make it, again, pretty low base. But in the Demer case, which I think is worth referencing, particularly the Supreme Court judge drew some attention to it, it did make reference to the positive obligation of a state to ensure that in conditions not at variance with Article 11, that trade unions should be enabled to protect their members' interests, and that is a positive obligation on the state. And in the Wilson case, it was also the right to be heard was very strongly advocated by the judges in that, and the right that trade union membership should not be rendered illusory or nugatory. And I think Ireland does nothing or very little to do anything about realizing even those pieces that are contained in the Article 11. But I think we also have to be, caution is advised when considering the case law in Europe, even the Demer case, because it should not be understood to mean mandatory trade union recognition for the purposes of collective bargaining has been conceded, because they have never conceded it, and that's the reality of it. However, EU law can be seen to accommodate and to indeed promote collective bargaining. And in the case of the ILO conventions, similar caution I would advise, because a lot of those conventions are filled with words like encouraging and promoting and doing all that good stuff. But when you go onto the ground and you're involved in a dispute, as I described, perfectly described in the Lloyd's dispute, promoting and encouraging does nothing to butter the parsnips when you're trying to settle that. That's the reality, and trying to have workers trying to vindicate their rights. So the way forward in the campaign to improve collective bargaining and trade union rights, I think it probably falls into two main categories. So firstly, we have the whole issue of constitutional amendment to void challenges to current legislation and to explicitly confer rights for workers. And in order to successfully achieve this, I think we are all long enough in this business to know that we would need to have a committed political will to develop and to authorize the necessary referendum that needs to happen to change our constitution. And so far, the experience has been that successive centre-right governments very closely aligned with the business community, and they are a huge lobby, and they're not just one lobby group, they are a huge lobby. They vigorously oppose any such development. I mean, I think that is not just a trite statement, that is unfortunately extraordinarily true. They have huge hearing aids into the government departments and so on. And so therefore, they have, you know, these governments have actually opposed any measure that the trade unions have put forward. So therefore, we've had a sort of a pattern of various different ways of trying to amend current legislation, of trying to do, because, you know, these governments successively have not been in any way, shape or form in the place where they wanted to agree referenda or anything else. Some argue to me now that a new order is on its way, and that centre-right governments as they currently exist may not necessarily into the near future. And therefore, all of the wishes we have will be conceded. I won't go into this in too much detail because I don't want to develop a political controversy, but all I will say is I don't necessarily see it that way. And I'm just saying we have to be very cautious about these things because promises don't always convert themselves in reality. So we just need to do that, even though there are some who advocate strongly that this is the case. I want to say this, if it is developed by there'll be nobody more pleased than me if that's what's delivered. Nobody more pleased than I. But the other piece that needs to happen is to have any chance in relation to the Constitution amendment and so on, we need to have an effective public conditioning on the value and the necessity of what is being advocated. And on that point, I think the tide is starting to turn somewhat. The pandemic, believe it or not, the establishment of who essential workers were, the establishment of the level of low pay in the country. And you can see a reaction now where people are not putting themselves forward for that level of low pay jobs and so on. It's now, and that's a worldwide phenomenon. It's not just in Ireland. And it's people saying, workers saying, we've had enough of this. Just, we're not doing this. And so I think that there is all of the economics now, all of the main commentators are saying collective bargaining is not bad for you. Collective bargaining is good for productivity. You've esteemed people like the IMF and World Bank, and all of these people are saying all of this. So I think it's also prudent, though, when you're traversing and considering that route, that you also have to measure the risk in relation to the possible defeat. I mean, it would be completely imprudent not to do that. I'm not making an assertion in relation to that. The final and second category of the options then that lie is the current European context. So ICTU itself, we are hugely engaged through our ETUC in current discussions on the draft EU directive on adequate minimum wage. And Article 4, as we know, without repeating all of the detail of it, but Article 4 of it does say that, or would mean that member states, if it were to be enacted in its current format, that member states where collective bargaining coverage is less than 70% of workers shall, in addition, provide for a framework of enabling conditions for collective bargaining, either by law, through consultation with the social parties, or by agreement with them, and should establish an action plan to promote collective bargaining. The action plan should be made public and should be notified to the Commission. So Congress's work at the moment is strongly to advocate for that directive at European level. And we advocated for the LEAF high level group. And I sort of was involved in that. I personally, I thought it was a very good idea that we should do that. And I thought that because I think we should never, ever, ever let the subject, the topic go offline. We have to keep this in their face. We have to keep doing what we need to do to get to where we want to get to. So through that LEAF group on the collective bargain, we are strongly advocating that the national law provisions, that we do not meet the killer line again, that in line with the national, that we make the national laws receptive to what happens in Europe. So the work of the high level committee, certainly for my part in it, I'm advocating that our national laws now have to stand up and be fit for purpose to enable us in directive terms as a first step in this, not as the entire picture, but as a first step, phase one of it, to be able to do that. Our laws are not capable of doing it at the moment, and I'm saying on behalf of Congress, we need to be in that place. And therefore, in our pocket as a piece of leverage, because once a trade union official, never not a trade union official, we're saying, if you don't do it, what you're facing is this referendum that you don't want. So there's our lads now, there's the choice you have. That's the sort of, now that's, I suppose, us converting it into a negotiation, if you understand, but that's the message. So if a new, in summary, I would say, if a new political order evolves soon, it is conceivable that you could see the enactment of legislation not dissimilar to what Daryl had referred to in the 2017 Act. However, trade union recognition has to be directly linked to the right to collectively bargain in order for it to be meaningful. And I completely agree with Daryl's contribution in his paper where he says we cannot become embroiled in what has been described, and he describes it as a swamp of procedural complexity as in the UK and the US. We cannot afford to do that. So I believe that, you know, the question finally that arises for us is, if we increase collective bargaining coverage, where do we stand with trade union recognition? And I think we can all agree that is the question. Reconciling the answer, I think, is probably the dilemma we all have. But if we operate in solidarity, even though we might disagree on the details, if we operate in solidarity, we have a better chance of achieving it. Thank you very much, Chair. I hope that was useful.
Thanks a million, Patricia. That was really appreciated. And I think, you know, there's that feeling where people with a similar objective, maybe slightly differing perspectives, can have a genuine conversation about the way forward. That's often quite rare in meetings, and I think it'll hopefully continue for the next while. So we'll give about 20 to 30 minutes to contributions. If anybody would like to respond to any of those two contributions, or indeed further the discussion, I can see Jack O'Connor has his hand up there, and Osel, who seems to be having difficulties staying with us, had also. So if there's anybody else, there's a function there at the bottom of your screen to put up, to raise your hand, or over on the right hand side. So you can do that there, or just notify me in the chat box there that you're waiting to speak, and I'll call on you. So Jack, would you like to come in there?
Thank you, Eilish. Are you picking me up there? Yes.
Yeah, that's grand.
Well, thank you, Eilish. And first of all, I want to compliment the Workers' Party on this very timely and important initiative. And also, I want to welcome the paper, the pamphlet, which is so well prepared by Daryl. And I also want to welcome Patricia's remarks here this evening. And one thing struck me about them, which is that both of them, in their own way, are so positive and so hopeful. I did actually, I should say before I say any more, I did counsel myself to keep my mouth shut tonight and to say nothing and to listen. And it may well be that by the time I finished, I'd be regretting that I didn't take my own counsel. But in any event, just to say in relation to Daryl's remarks and the pamphlet, Daryl said something this evening that I have never heard said before. And perhaps it was said, and I just didn't pick it up. But because obviously I have been present when this issue was debated ad infinitum over nearly a quarter of a century. But the point that Daryl made, if I understood him correctly, that I have not heard before, is that the signatories to the convention are obliged to comply with the rulings or the findings of the European Court of Human Rights unless they conflict with their constitution. And I actually haven't heard that argued before. Maybe it was argued in my presence, and I didn't pick it up. Now, of course, that is enormously significant. But it is possible up to now that it would have fallen at the first fence, because that comes down to the way our Supreme Court interprets our Constitution and interprets the concept of freedom of association. And as you point out, heretofore in our courts, it has been, in the High Court, it has been interpreted as entailing a right on the part of employers not to associate and not to negotiate and so on. It could well be that we would find ourselves in a situation in which legislation was enacted and it was tested and they came up with that same old result, notwithstanding what you've said about the convention. But I do think that the recent decision, the recent Supreme Court decision, the McMenamin decision on the SCO could well reflect an important departure on the part of the Irish judiciary. And as Patricia has pointed out, this departure is evident on the part of the centre-right, the establishment in Europe and in the USA. I think, ironically, as a result of the shift of the working class to the far right, and because whereas they're prepared to deal with the far right in several countries quite happily, they do see the danger of that development bringing the whole house, the whole European project, single market, the whole lot down on top of them. I think the reasons for that departure in the US are slightly under the Biden administration are slightly maybe more progressive, but in any event, they are as a result of them realizing the inevitable result of the policies which were pursued in the post 2008 period and the development of the far right. Now, so I agree that there is an argument to be made, and I would like to see it argued out. Without getting too political about it, my own party advanced the right to union recognition as one of 5 preconditions of participating in or supporting any government after the last election. Now, the reason I'm saying that is not to make a political point, but it's this. It's that in the evolution of the decision to promote that, there were lots of legal debates inside the party. And the party, the advice ultimately was to the effect, along the lines of what you're saying, Daryl, that we could legitimately legislate without running foul of the Constitution. And the idea was that legislation would be promoted to see how it got on, rather than running the gauntlet of trying to win a referendum. Because all of those forces that Patricia has referred to, that are funding all these cases and all the rest of it, they would be deployed to multiples of 10,000 to ensure that that referendum wasn't won. And also, as Patricia said, you have to think through the consequences of losing such a referendum, because it won't be just things where things will stay as they are. That's not the way things happen. All of you know that as political people. But I'll shut up now and say I want to compliment the Workers' Party on this initiative, and to compliment you, Daryl, on this paper. And I would like to see it argued out in detail, as I'm sure it will be. But most particularly, I want to compliment you all on the way you've brought forward this initiative at this crucial moment, against the background of the work that Patricia is engaged in on that committee. It's most timely, and for what it's worth, I very much welcome it. Sorry for going on so long, Eilish.
That's no problem. Thanks very much, Jack, for that, and thanks for the encouragement. Right, so I have also coming in to speak there, and also Norman. And if anybody else is looking to speak, do put up your hand or signal in the chat box to me there, just so that we know who's coming. Okay, also.
Can you hear me okay?
Just about. You're breaking up a little bit, but go ahead. You can always type it in if you need to.
Okay, well, I'll try and speak slowly, and hopefully you'll pick it up. So thank you both for very comprehensive and
Sorry, also you're on mute there somehow. Yeah, you're grand now. Yeah, go ahead.
Sorry, yeah, I just wanted to thank you both for very comprehensive and interesting presentations. Patricia King noted that the right to take industrial action should be retained in any future reforms, which I would agree with, but unfortunately it is quite limited as it is. The Industrial Relations Act 1990, and incidentally the Untying Workers Hands booklet referenced by Daryl, which he had put together, is excellent, but that legislation effectively prevents secondary strikes and political strikes, both of which have played a vital role in the progress of the labour movement. I would submit that there is a need for the trade union movement and the Irish Congress of Trade Unions to take a clearer position supporting calls to repeal the 1990 Act. And I would just be interested in the speaker's response to that.
Great, thanks very much, Osel, and I'll come back to both the speakers at the end. So if you'd like to maybe make a note of any questions or concerns, we'll see how time is going. Might do 2 rounds. Okay, Norman and then Paddy. Norman, go ahead.
I would like to join with Jack in saying that I found the contribution of Daryl's and of Patricia's quite interesting. However, one of the major problems that I have in regards to the entire debate is the absence of a commitment by the trade union movement to confront the challenge that has been most evident in the last decade. Patricia rightly and Daryl rightly went through the various legal challenges to the 1946 Act, etc. Since 2001. And in regards to the legislative responses to the decline in trade union membership, to me, it has to a large degree corralled the representation role of the trade union movement
to the existence of recognition by the employer. And where an employer doesn't recognize a trade union, there is no mechanism to ensure fair representation of workers within work. And for instance, Daryl referred, I think, to the Trade Union Representation Miscellaneous Provision Bill. And we've seen Dempsey saying in regards to that bill, that the right of association does not place any requirement to recognise or negotiate with a trade union. And the implications arising from that is there is no obligation on an employer to recognise, negotiate, or allow for representation in respect of the Constitution. There is no clear evidence that the trade union movement has responded to the legal attacks on vulnerable workers since 2001 in any concerted national campaign. There has been no evidence of the trade union movement organising a campaign around the judgments that have been made and the statements being made in the Dáil in regards to the question of union recognition. It is not sufficient that we would talk to the government about amending legislation or introducing legislation if we're not simultaneously talking to the community about the impediments that have been placed on workers in the absence of the rights to collective bargaining. The trade union movement, and Patricia quite rightly articulated it, is the largest civil organisation in Ireland, with offices and resources spread throughout the 32 counties. And there has been an absolute failure on our part to influence society's opinion of the legitimacy and the right to have collective bargaining and trade union recognition. And we have answers as to why we don't collectively confront this issue without putting forward a reason as to why we should not, at this stage, be out there campaigning for those rights, to establish that we either achieve it statutorily or we achieve it by amendment to the Constitution. Failure in any campaign, we cannot say with any absolute confidence that we will win or that we will lose. But we can say with confidence in regards to any campaign that we will achieve nothing if we do nothing. Thank you very much.
Thanks, Norman, for that. Okay, I'm going to bring in Paddy and then go back to Patricia and then Daryl. If anybody else would like to come in, just indicate. Paddy.
Hello, thanks. And look, just thanks for everyone for the contribution, and to Daryl and Patricia in particular. As somebody who was kind of a union that were involved in the recent SEO, probably challenging to the High Court and Supreme Court, probably more intimately than anybody else. There was a reference by Justice McMenamin. I just wanted to know what Daryl might think of this, where in his judgment, he said, while he gave his reasons for the judgment, he did say there may be an issue in relation to the freedom of association. And that is in the judgment. Now, it could be that, as Kevin Duffy's summary was, in relation to the how it will impact on agreements, because an SEO is different. It's an order for the sector, but the judgment said that it might have an effect on in relation to industrial orders or agreements, because they're agreements and you can't force a person into an agreement. So I was just wondering, was that, he left it open. He didn't really say why. And I'm just wondering what that could have meant, because, or how we could interpret that, because it could be in relation that we say to the REOs or in the future or other agreements. But then how about in relation to what Daryl said earlier on, maybe it's in relation to the interpretation of what the freedom of association means. So I think that's something worth exploring. But as regards union recognition, look, there's not one trade union official or member or anyone you would talk to who wouldn't be for union recognition. It's how we go about that. And it's not, there's no one answer. It's a many and different pronged approach. And we should probably take a leaf out of the employer's book and actually look how we can combine together rather than pick holes in each other's arguments, how we can combine together and have these different fundamental, a multi-pronged approach to fighting for union recognition. Because there's no doubt what Patricia said is right. The contractor who challenged the SEO, including himself, has 6 people working for him. The association that challenged it has in their bank less than €10,000. So somebody is financing these people. Somebody is standing behind them and saying, we will help you out here if things go wrong. So if we're an organization with 800,000 people, maybe we should be looking at how we can work together to further the cause of union recognition. And if that means working together or maybe levying our members or whatever we have to do to have that multi-pronged approach, we should. But I would be interested to hear what Daryl had to say in relation to that part of the judgment. Thank you.
Great, thanks very much for that, Paddy. Okay, I'll bring in Patricia first and then Daryl to respond to those comments, whatever you'd like. While they're doing that, if you do want to come in, just indicate in the meantime. Thank you.
Okay, thanks very much, Chair. I'll just make a brief, if I might. So firstly, if I might just make reference to Ussel's comments in relation to the 1990 Act. So he raised a few things there. Firstly, the secondary picketing. Now, unfortunately, I'm long enough around to know and to having been involved in disputes before the 1990 Act. So I actually have direct experience of what it was like to be involved in. And I remember I came out of the car trade, and if you weren't on strike every second day, you weren't doing what you should have been doing. And at one particular case, we were out for 9 months trying to secure our jobs, which we ultimately failed to do. But there was a lot of garages around the place, and we put pickets on them to stop the cars moving. We put pickets on Rosslare Harbour, all the usual things that you'd expect to be able to do. And what we did succeed in doing is we cost them a lot of money. I kept all the papers actually on it. I got 35 injunctions against me over the period of that 9 months. Myself and the late Charlie Mooney and other people. Mick O'Reilly's on the call. He will remember some of this because he was engaged in some of it himself. And you'd say, well, what was the value of the secondary picketing? It was valuable. I think the provision that in the 1990 Act, which says you can do secondary picketing if you can prove that the company you're putting the secondary picketing on has in some way been interfering with or in some way engaged in stopping your legitimate dispute. I have to say, just the way I have always operated, I think Jack might understand what I'm saying. I never gave too deep contemplation to those provisions. When you were involved in a dispute, you did what you had to do. So I never let them interrupt what it is I wanted to do in terms of executing the dispute. Now, some would say that's skating very close to the line of ignoring the law. Maybe it is, but that's the attitude I always took in it. I do think Daryl raises a very relevant point in relation to the governance and the interference through the 1990 Act and the provisions of the internal governance of unions in relation to ballots. And I think that there have been moves in certain disputes recently that came before the court to, there have been moves to sort of try and maybe curtail the behaviour of unions by overusage of that. So I personally disagree with that in the Act. I don't think, I do understand about the immunity to trade unions in terms of how you execute your dispute. I understand that, and those of us who are through the Nolan dispute understand all of the, I suppose, intricacies of that. But I think that there are pieces. I wouldn't, the political dispute piece, you may very well be right. It's not something that I have overly concentrated on. just in relation to Norman's overall comments there, if you do nothing, I think that personally is a little bit unfair on the movement, because the movement usually does its business by the execution of successful trade disputes. And I don't think that the Irish trade union movement over the last 2 decades could be accused of, and indeed you were a member, a colleague of mine in SIPTU at the time, and you took part in some of the assistance with these disputes. We had some of the best, maybe I should rephrase that, we had some of the most effective trade disputes. And what were we doing in that? We were highlighting to all of the powers that be, here's what workers want, here's how we need to do it, here's where the deficiencies are, and you as an establishment need to put those things right. Now, that's much more effective in my judgment than I hawked myself around in my first year as General Secretary of Congress with a charter for rights for trade union membership and all of that good stuff. I can tell you I went to every single politician, left, centre, far right, far left. I sat in their offices. I made sure I ticked the box for every one of them. And I can tell you that quite surprisingly, even in the cases of some of those who claim to be far left, they didn't even understand what a JLC was. Never mind understand the intricacies of trade union recognition. So I'm merely saying to you that I wouldn't fully accept, I understand the points you made, but I think the trade union movement has boxed in some cases way above its weight. When you look at the density levels in the private sector, when you look at some of the disputes we brought to this state and executed in this state, and can still do it. Because remember, even though the density levels in the private sector are low enough, the density levels are very high in the places they need to be high. And that's the big, big positive for our movement. And we should never let that go. And that's why the other side has to sit and has to talk and look at lowlife like me across the table and listen to me bleating on about what we should get and what we shouldn't get. That is why they do it, because they know we can execute. And I mean, you know that even in the last 2 years, we executed one of the biggest strikes that the country ever saw, and we did it quite successfully. So I'm not, maybe I have picked you up incorrectly, but I'm not sure that I entirely agree with the point Norman is making. So I'd leave it at that, Chair, if I might.
Great, thank you, Patricia. Daryl, would you like to come in on any of those? You're on mute there, Daryl. Bottom left of your screen. There you go.
Am I unmuted?
You're unmuted. Go for
God
it.
help everybody. But happily, I've very little to say. You know, I'm actually torn between the discussion going back and forth there, because I'd be sympathetic to both positions, which is really, that's a very academic and wishy-washy position. But yeah, it's the business about Norman's point about unity, and I'd be sympathetic to that view, of course. And well, other people have made that point as well, and it really is important. And of course, sort of people who, you know, are maybe, you know, not that active in the union movement, maybe don't know what's going on and all the rest of it. So I'm reluctant to sort of say anything there. I'm going to do my on the one hand and the other hand, whatever you say nothing. But about the McMenamin judgment and its reference to freedom of association and what it might mean, frankly, I don't know. It could. The fact that he mentioned it at all is sort of maybe semi-significant, but we wouldn't want to read too much into it. You know, and he obviously, I think he must have been reasonably well disposed to the arguments that were put forward in the jurist article. Of course, if that will have any practical effect, that's another question altogether. But yeah, no, I wouldn't really know. It might be favorably disposed towards our view of things, or it might indeed be against. We won't really know until it's tested. But actually, being tested in the courts is never a good way. I was struck by Patricia's thing about the 1990 Act and about secondary action, yeah, wouldn't you be foolish to go to the court and the court question you about can you prove that the employer, that you're taking secondary action against was intent on disrupting it? It'd be very difficult, and you wouldn't be at a sympathetic, might not get a sympathetic hearing. Yeah. So in short, about the McMenamin judgment, I'd only be guessing and speculating. I can't answer that. That's all I've got to say for the moment, Ailish. It's sort of inconsequential and going nowhere, but that's what's happened to me.
A great note to finish on, Daryl. Well,
no.
I'm just looking there. So, yeah, Kathy, would you like to come in there? Actually, Kathy Shields. I won't try and paraphrase your sentiments. I don't think you sent it to the group.
No, I didn't send it to the group. I'm always a bit nervous about speaking at these meetings because I'm so naive sometimes, I think, when it comes to organizing, and because of my age, I've only experienced, like there's my cat, like positive outcomes. So it was just sort of whenever folk were talking about, like there being a potential referenda, I ended up thinking that would be really marvelous, maybe, and it could be like a really good opportunity, given that there's a bit of a dearth of young folk involved with the trade union movement, that sort of coverage and engagement, just that it would be really interesting to work with all of the various different trade union organizations on something like that, So just if it comes to that, maybe don't worry about it. Hopefully the recent referenda are an indication that we can win these fights.
Yeah.
Thanks, Kathy. Okay, just one moment there, Daryl. So I'm going to just confirm, I don't think that anybody else has indicated they want to come in. So I'll hand back over certainly to Daryl to conclude, and Patricia, if there's anything you'd like to say there briefly just to conclude. So Patricia, maybe I'll just hand over to you briefly and give the last word to Daryl, unless if you've already
done. So I just think, firstly, thank you again for asking me to contribute. I think it was a good opportunity to have a very good airing of the issues that are involved, complex and all as they are. I think we should have more of these type of debates on this. And as Kathy said, you can never predict what the outcome is going to be, because, there may very well be lots of interest in pursuing one avenue over another. All I do know is that I can agree entirely with Jack. This is a very important moment. We have to utilize the opportunities we are given when we are given them, and we have to take, even if we don't get everything on the first go, you have to step by step to achieve what it is we want. And that's, I think, the focus of ourselves in Congress on behalf of all the affiliates who are fully engaged with us on this in this conversation. And I think that's what we're about at the moment. Thanks very much.
Brilliant. Thanks, Patricia. And Daryl, over to you.
I'm not really going to have the last word. You're going to sort of close the meeting.
Yeah.
But there's some dodgy characters of this. I saw that fellow Mick O'Reilly. He's a dodgy sort of.
And he stayed silent the whole way through.
I know. I can't understand it. I can't believe it. But no, just I forgot about. Jack was talking about the referendum. I must say I'd be uneasy about that myself, because there would be massive opposition to it. There must be a better way, as they say, because it's too dodgy. It'd be very difficult to frame the question. I really, if it was the only way forward, well, it might have to be done. But Jack, I think, is right. There would be massive opposition to it. Other referenda, and I won't mention any of them for fear I might get into trouble, but other referenda were not difficult, actually. There was a small minority, but the majority, the press, the sort of people generally were for it and there was really no difficulty about it. All sorts of people from the left and the right agreed with these things. But on a question like union recognition, it might be a completely different matter. Surely there's a better way. Surely we can say, oh, you know, my idea, oh, look here, maybe I'm being naive. Look here, we have a freedom of association, constitutional right, and that really means that we should be, and we want it in action, please. That sort of thing, that sort of agitation. But a referenda, I think, could be on a question like that, as Jack pointed out, it could really raise really stiff opposition, and we might lose. And then we'd be up to Swanee. So I'd be sort of careful about that. But that's a bit of a negative note to end on. So I'm going to leave you, Ailish, to do the positive thing. Oh, by the way, thanks for everybody for coming, and Patricia and all the other contributors. And I was a bit disappointed that I didn't hear anything from Mick, but that's neither here nor there.
Okay, I'm going to be very comradely here and allow Jimmy to say a couple of very short words. But I will conclude then. So Jimmy, just a couple of sentences.
Okay. Well, I didn't intend speaking, and thanks again. It was a great debate, great day, a great night. But taking up the point that you made, Daryl, that if we can't use the referenda route, well, then we're going to have to come up with something. We're going to have to come up with some very clear way forward. You can't keep saying, well, you can't do that. But at the other hand, you know, the thing is just rolling out, and they're rolling us over. And we have to try and find some way that if you say you can't use the referendum, and maybe that is correct. Now, nobody that I know is proposing that we throw ourselves on our swords, that, you know, we rush into this in a headlong way without any thought or any rationale. I take the point that Jack made or Patricia made, that if you are going to go that route, you have to build, you have to meet people, you have to build a consensus, you have to talk to people. I accept all that. But if you say, Daryl, no, that's not the way forward, well, then what is the way forward? People have a right to ask, what is the way forward? How do we get out of the bind which we're in? And which I agree with Patricia, the trade union movement has done there reasonably well over the last number of years. And in fact, you know, we have won some very important disputes, and I recognize all that. But at the same time, there is that in the corner that we don't have the right to represent people. And that is a cornerstone. And somewhere along the line, you have to try and square that circle. I don't know how it's done, but we have to think about it, and we have to do something about it. Thanks.
No problem,
Jim. Thank you.
And I think that that's probably, I suppose, the starting point for future conversations, hopefully. So look, I'm not going to try and sum things up in a positive way. I think the conclusion of Daryl's pamphlet, and Patricia's right, it will be published more or less as a book, and hopefully will be something that people will like to have a hard copy of when those things become normal again. But the conclusions do provide, I think, a path, and it's one that I think we can continue to discuss over the next while. So I just want to say thanks a million to everybody for coming and for having such, I think, a useful and comradely discussion from many different perspectives. I think there's just a huge breadth of knowledge here, and it's a breadth of knowledge that I think should be talking to each other more. And personally, it's really great to see familiar faces. I think everybody's been somewhat isolated over the last while, and it's lovely to see familiar faces again. And I'm looking forward to seeing everybody in Liberty Hall for a similar conversation in the not too distant future. Or actually maybe Connolly Hall down in Cork now that I've relocated. I'll bring you all down. So thanks a million, Patricia especially, and to Daryl, congratulations on a really excellent book. And I look forward to discussing it all with you all again in the future. Thank you very much.